Hello and welcome to Topic 8, Lecture 1. And in this topic, we are going to be learning about searches and warrants. So, what are we going to be covering in this lecture? Well, first, we're going to talk about the role that civil liberties play in the criminal justice system. In this chapter, we're going to be focusing primarily on the role of the Fourth Amendment and also the Fifth Amendment as it relates to the police. However, as we move on to the other chapters within the textbook, we're going to see, particularly as it relates to, what goes on in a courtroom, we're going to see that there are other parts of civil liberties that have a huge impact on criminal justice. And so first, we're going to just embed this in the thinking about criminal justice in relationship to civil liberties. Then we're going to focus on the Fourth Amendment and the two clauses that are in the Fourth Amendment. And then we are going to talk about what a search is, okay? Because this chapter is dedicated to searches and seizure. So we're going to define how the Supreme Court has defined what constitutes a search. And then we're going to take a look at the requirements that are necessary for a warrant. And those requirements are actually outlined in the Fourth Amendment. All right, so that's what we've got on the docket. Let's go ahead and get started. So much of the law that governs the action of police and also other criminal justice agents and institutions are derived from the Bill of Rights, okay? And I think most of us are familiar with what the Bill of Rights are. The Bill of Rights are the first 10 amendments to the United States Constitution. That initially, the U.S. Constitution did not have a Bill of Rights, but in order for states to agree to ratify the Constitution, they wanted to make sure that there were limits that were placed on the power of government and that protected the rights of individuals. And so the state said, look, we'll ratify this Constitution, but only if you add a Bill of Rights. And so the Bill of Rights are the first 10 amendments. And now the Bill of Rights are often referred to as civil liberties, okay? And so what civil liberties are is they're basically your individual rights, okay? And so they're the individual rights and the personal freedoms with which governments are constrained from interfering. And so civil liberties are really telling government what it cannot do, okay? And so I often tell my American government students that civil liberties are like the thou shall nots. It's a listing. The Bill of Rights is a listing of what government cannot do, okay? It can't not infringe on your speech. It can't infringe on the press. It can't search you without reason. And so basically the Bill of Rights is telling government what it can't do. And in telling government what it can't do, it's opening a space for your own individual freedoms, right? So that you can, engage in your life in a way that is free and is not always being monitored or controlled by the government. Now, why we're talking about the Bill of Rights in this class is because that a lot of the Bill of Rights is dedicated to the rights of the criminally accused, okay? And so 4 of the 10 amendments, okay, the 4th, the 5th, the 6th, and the 8th deal with the rights of the criminally accused or rights regarding the activities of criminal justice agents like the police. And so the 4th Amendment talks about search and seizure. The 5th Amendment tells you about that you can't be charged twice and that you have a right to remain silent. And the 6th Amendment tells you about all of your jury rights. And then, of course, the 8th Amendment gives us guidance in terms of what government can't do or what kind of punishments government cannot engage in. They can't engage in cruel and unusual punishments, okay? And so a lot of the Bill of Rights is focuses on the rights of the criminally accused. And that might initially seem sort of odd to you, like why so much emphasis on that? But the framers and those who wrote, James Madison, who wrote the Bill of Rights, they really, knew and had experienced as colonists that when a government wants to charge somebody with a crime and convict them and, try them without and find them guilty, that it's easy to do that if there aren't any restraints that are placed on government. And so they wanted to make sure that in the Bill of Rights, there were clear restraints placed on government when they were dealing with criminal matters. And that's also because if there are these restraints, then we know that when somebody is found guilty, that we have confidence that they were found guilty even though they were afforded a robust series of rights. So here's a listing of the amendments that deal with the rights of the criminally accused. So as I mentioned, and what we're going to be focusing on in this lecture is the Fourth Amendment that deals with searches, seizures, and warrants. That the fifth, and when we use that word seizure, we're talking, an arrest is considered a seizure. Okay. The Fifth Amendment, as I had mentioned, that it tells you that that all people have a right to due process. That is, that government can't take away your life, liberty, or property without the due process of law. It establishes that you have a right to a grand jury, at least at the federal level, that you are not subject to double jeopardy, that you can't be tried twice for the same crime, and that you have the right to remain silent. And so the right to remain silent is also covered in this chapter. The Sixth Amendment are your trial rights, not most importantly, but that the fact that you have assistance of counsel, a constitutional right to have a defense attorney. We'll obviously be going into those in more detail in future lectures. And then the Eighth Amendment is saying that when it comes to bail, it can't be excessive, nor can a fine. And also a punishment can neither be cruel nor unusual. And it's the Supreme Court who determines what constitutes cruel and unusual punishment and excessive bails and fines. All right, so let's turn our sights to the Fourth Amendment. All right, so the Fourth Amendment is about privacy. It's an amendment that is basically saying that individuals have the right to have a personal, private space, whether it's their home or just an area where one considers it, that there's a reasonable expectation of privacy, your effects, the things in your home, that the government can't intrude upon those private places unless they have a really good reason. And so it, like all civil liberties, it tells government what it can't do. It places limits on governmental power. And in this case, it places limits on governmental power as it relates to privacy. And so the Fourth Amendment does two things. The first thing that it does is it places limits on the power of the police during search and seizure, okay? And so that when it comes to the seizure of a person, which would be an arrest, it basically gives guidance in terms of what needs to be in place for police to seize somebody, to arrest them. It also gives us guidance on how people can be searched, both how the person can be searched as well as their property. And then it also tells us and gives us guidance on the seizing of objects and contrabands, drugs, weapons, things that are thought to be involved in the commission of a crime. And so one aspect of the Fourth Amendment tells us about places limits on searches. The other aspect of the Fourth Amendment is that it actually tells us what requirements need to be in place for a legal warrant, okay? And so, again, it places this limit. If government's going to get a warrant, it must establish these facts, okay? And so actually, let's look at the language of the Fourth Amendment and see how there are two clauses that deal with the first thing, placing limits on a police search, and the second thing, the requirements for a warrant. Okay, so let's take a look at the language of the Fourth Amendment. There are two clauses in the Fourth Amendment. The first clause is what is known as the reasonable clause, and the second clause is what is known as the warrants clause, okay? And you know that while there are two clauses, these clauses aren't necessarily connected. So let's take a look at the first clause. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. So what it's basically telling the state is that the state can't engage, they can't enter into a person's private area, their home, their property, their effects, without good cause, without reason, okay, without probable cause. And so, you know, basically it's saying that for government to engage in a search, that search must be reasonable. Now, there are some times when as we're going to find out, that you don't need a warrant to engage in a search, even a reasonable search. There are exceptions to the need for a warrant. However, if you get a warrant, there are things that you must get. Law enforcement is the one who seeks out warrants. And so if law enforcement wants a warrant, it says that warrants won't be issued but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, so the warrants clause gives guidance to what needs to be in place for a warrant to be granted, and that warrant being granted then kind of make sure that there's this sort of check on the power of law enforcement to engage in a search when in fact they should not be engaging in a search. Okay, so now we have a sense of what the Fourth Amendment is. Let's talk a little bit about what constitutes a search. So the word search, as used in the Fourth Amendment, it's not anyone looking for something, okay? It's not anyone searching around for something. In the context of the Fourth Amendment, the word search has a very distinct meaning. The meaning is that search, as used in the Fourth Amendment, is about a government agent infringing on a person's reasonable expectation of privacy, okay? That's what a search is. That is how a search is defined in the Fourth Amendment. For one thing, the Fourth Amendment is telling, or in all amendments in the Bill of Rights, is telling government what it can't do, okay? It's not telling private citizens or private corporations what it can't do. The Bill of Rights is placing a limit or a restriction on the actions of government. And so the Fourth Amendment is basically saying that government is limited in how it can search, right? And that a search is when a government agent infringes on a person's reasonable expectation of privacy, which we'll talk about in a second. That's sort of a fancy way of saying it, but a more straightforward way of saying it is that the Fourth Amendment applies to police searches. It doesn't apply to a private employer searching you or a private citizen searching you. Your friend could come over to your house uninvited, and they could go through your things, right? They could search your house, and they could find something, and they could turn it over to the cops, right? The Fourth Amendment doesn't apply to private citizens, okay? Now, that might be problematic. I don't know if police would necessarily, take and use contraband that was turned over to them by a private citizen. Maybe they would, maybe they wouldn't. The private citizen could definitely get arrested for trespassing. Same with a private employer. A private employer, the Fourth Amendment doesn't apply to a private employer. They can search your locker at work and those sorts of things, unless there are state laws that are prohibiting that kind of action. And basically, the Fourth Amendment doesn't apply to the actions of those private entities because they're not government agents, and therefore it does not constitute a search, at least in the way that search is defined in the Fourth Amendment. So in the context of the Fourth Amendment, for there to be a search, it must be of a place where one reasonably expects privacy, okay? And so from the Fourth Amendment's perspective, it is a government agent searching a private place. And so if a private place is being searched, then the Fourth Amendment would apply. That doesn't mean the Fourth Amendment is necessarily violated, but you'd have to say, okay, what is being searched is private. Therefore, you either need a warrant or that search needs to be reasonable. If it's not, then the Fourth Amendment would be violated. But if the place that's being searched is not considered private, if it's considered public, or that there's really no reasonable expectation of privacy in that place, a search has not occurred, and the Fourth Amendment isn't even relevant because the Fourth Amendment only applies to searches. And so let's take a look at some examples or hypotheticals and ask ourselves, okay, if a search took place in this arena, is there a reasonable expectation of privacy? So the first one, you're having a conversation with your friend on your couch in your living room inside of your house. Is there a reasonable expectation of privacy there? Absolutely. And if the cops wanted to listen in on your conversation inside your home, they would have to get a warrant or have some sort of probable cause to do so without violating the Fourth Amendment. But if you're having a conversation with your friend on a park bench in a public park and law enforcement, you didn't know that they were law enforcement, but they're sitting next to you and listening on your conversation and using that, that is not a violation of the Fourth Amendment. It's not even a search because there's no reasonable expectation of privacy about having a conversation in a public place. How about you put trash in a can and place it on the street for pickup? Is that a private place? Do police need a search warrant to go through your trash can that you've put on a public thoroughfare? The answer is no, that doesn't constitute a search. In the case California versus Greenwood, they basically said that when you put your items in the trash can and put it out on the public street, it becomes abandoned property, and there's no reasonable expectation of privacy when it comes to property that you have abandoned. And so they can go through your trash can without a warrant because it's really not a search and the Fourth Amendment doesn't apply. But if you put trash in your trash can and your trash can was on your porch, now, yes, that would, there is a reasonable expectation of privacy there because your porch is what is considered curtilage, and that's like the part of your house that extends, like your porch, your backyard, your garage, and it's considered a private place. And if cops wanted to go through your trash on your porch, they would need to get a search warrant or have reasonable cause to do so. A great case is Kylo versus the United States. That's where police, they thought this guy, Kylo, was growing pot in his basement, but they didn't have enough information to get a search warrant. So they camped outside his house. They had a thermal device in order to see if his basement was had a higher temperature than the other basements around him. And indeed, it did have a higher temperature, and then he used that to get a search warrant. The Supreme Court said no, that yes, that is a search, and that doing that, you need to have a warrant to use that thermal device. And if you don't have a warrant, then you violated the Fourth Amendment. So they say that what goes on in your basement there's a reasonable expectation of privacy, and using a thermal device to look into the privacy of your basement, that clearly violates an individual's reasonable expectation of privacy. The Supreme Court has said that the flying over the backyard to take pictures and using it in a criminal case against you, there is no reasonable expectation of privacy. In other words, that it's airspace and people can fly over your backyard and look into it. And if cops want to do that, fly over your backyard, there's no reasonable expectation of privacy in a flyover. Now, on the other hand, if cops came into your backyard and then they got a ladder and then climbed up over the ladder to appear into your backyard, that would be different because it's not really airspace. But in this, that they're flying over your backyard, there's no reasonable expectation of privacy. And there's also no reasonable expectation of privacy in a public airport. You're walking through there, people can see your face, and if police want to use facial recognition technology to thwart terrorism, they're well within their rights to do that. So as I mentioned before, that people do have a right to their privacy, to be free from government intrusion into their private places. However, this right is not absolute, okay? That the government may need to intrude into your privacy, particularly if what you're doing in the private in the private is going to harm others, right? That you're engaging in some sort of conspiracy to commit a crime or terrorism or what have you, right? And so the government has a right to intrude into that private area because the government has an obligation to prevent that kind of harm to the public welfare. However, to do this, to intrude into that privacy, the government needs a substantial reason to intrude. And we've been using the word probable cause several times throughout this lecture, so now it's kind of important that we define what we mean by probable cause. And so in order to intrude into this privacy, the government needs to have a substantial reason, and that is probable cause. And probable cause means that it's reasonable to believe, based on the evidence, that a crime has or is being committed. Okay, and where you get that, that evidence, that becomes a part of the police investigation, right? And so if you think that somebody's involved in a crime in their home, in a private area, you might sit outside and watch who's coming in and out of the house. You might look at their energy bill. Like if you think that they're growing pot in their basement, see if their energy bill is higher, if you're able to get that information. There might be an informant that you might talk to, right? And so based on that evidence, if there's enough evidence to say, well, it's reasonable to believe that there's a crime going on in here, then at that point that the government has the right to intrude upon that private place. Oftentimes, when there is a substantial reason for for the government intruding upon somebody's privacy, usually what the government does is, in order to engage in a search of that private area, that they get a warrant, okay? And we're not going to spend a lot of time on this because we sort of already covered it in the Warrants Clause in the Fourth Amendment, and you can read more about it in your textbook. But as outlined in the Constitution, that if law enforcement is going to get a warrant, that there are 3 requirements that it must satisfy before a warrant is issued. To get the warrant, the warrant must be based on probable cause, and so warrants are granted by the court. Okay, and so law enforcement, that they take the evidence from their investigation that is substantiating the fact that there's reasonable belief that a crime is taking place, and then they bring that evidence to a judge or a magistrate, and then they make their case that, in fact, based on the evidence, that it's reasonable to believe that a crime's going on. And then the judge is sort of a check on the power of law enforcement, right? They can say, no, you haven't established probable cause, go back and get more evidence. Or they say, no, you have established probable cause, and therefore I can issue you a warrant. And then finally, that the warrant has to be particular. There has to be particularity to the warrant. Just because you have probable cause doesn't mean you can search wherever you want, okay? That the search has to be related to the evidence of the crime. And so in a warrant, again, to place an additional limit on the power of law enforcement, the warrant will designate of the area to be searched, who's going to be searched, what areas of a home or an RV or whatever it might be are going to be searched. And so those are the 3 requirements that are necessary for a warrant, and you can read more about that in your textbook. So getting a warrant to search is preferred, right? You've got the warrant, you've established probable cause, and you've got basically the check of the court system to make sure that you've got that probable cause. But it's not always practical to get a warrant, okay? Getting a warrant takes time. And if a crime is going on and lives are in danger, there just may not be enough time to get a warrant. And so that there are times when it's reasonable to waive the warrant requirement, okay? And that, that's what's known as, exceptions to the warrant requirement. When you search without a warrant, it's known as a warrantless search. And warrantless searches, or searches without a warrant, can be legal. And so we're going to be learning about exceptions to the warrant requirement in the next lecture. All right, thanks for listening to me, and I appreciate your time and attention. I'll talk to you again soon.